Hello, Assalamu alaikum. Bismillahirrahmanirrahim. I am Dr. Javed Iqbal Khokhar, Professor of Forensic Medicine and Toxicology. As I am discussing the law related to medical men, and this is the fifth lecture of this series. And in today's lecture, I will be discussing the evidence recording in the court of law. And the contents of my talk will be that I will be discussing what are various stages of evidence recording. And we know that they are the examination in chief, the cross-examination, and re-examination. The testimony of a doctor, that how the evidence of the doctor is recorded, we'll discuss that. And after the oath, all the stages of examination, they are carried out. Then we'll also learn that there is an invisible triangle. That means on the head chair of the court, the judge is sitting. On the right side is the defense lawyer, and on the left side is the prosecutor. And you, being the doctor, are being presented by the prosecutor in the court of law. So these three make an invisible triangle, and we'll discuss how to take care of the questions and to whom you should address. So starting with the topic, the evidence recording. The stages of examination in the court of law, when you are presented as a medical witness, they are recorded in three stages. That is examination in chief, cross-examination, and re-examination. Then what is examination in chief? The examination in chief is the first and the main component of the evidence recording. And the party who produces the witness, he conducts it. And the facts which are deposed in front of the court, they are basically the examination within your memory and recollection of the witness. So normally these facts are based on the evidence of the person by recalling his memory and recollection of the memory, then it is presented in the court of law. But only the technical witnesses like doctors, ballistic experts, they are allowed to refer to their written notes. For example, we being the doctor, we prepare the medical legal record, MLC of the living person, and autopsy report for the dead. And these records we can bring in the court and we can read it out as an examination in chief, the findings which we have narrated down or written down. Then the most important thing, and this is only the witness deposes, he only present the evidence which he has perceived, and no leading questions are allowed in this stage of examination. Then the cross-examination. The cross-examination is basically the second part of the evidence, and which is conducted by the party who is defending the case. For example, when the doctor is being presented by the prosecution, then the cross-examination will be conducted by the defense counsel. And this is required basically to test the credibility of the witness and the accuracy of the witness and willful omission of the facts. If the defense has observed during the reading of the facts that something has been missed willfully, then he can ask the witness and the witness has to defend himself. Then leading questions are allowed in this case because there is cross-examination. The defense is going to ask you the question, whatever he thinks related to that particular case. Then the re-examination is the third stage, and this examination re-examination is the third stage of the evidence recording. And during this stage, an opportunity is provided to rectify the discrepancies which arises during the cross-examination. For example, if there is some gross discrepancy which can harm the case, then that discrepancy can be rectified by the counsel who has presented the witness. Then this is important that the court may ask questions during any stage of examination to clarify the facts. Now, the testimony of the medical practitioner, that is the evidence recording of the doctor. The evidence recording of the doctor in the court of law is on the same principle, and this consists of basically two parts. First part is that the doctor produces the facts which he has recorded as a common witness when he examining the case, and he records the facts, like if he has received the case of injury or poisoning or disease, what he had observed during the examination, they are presented to the court of law. For example, in the case of injury, its site, size, shape, depth, margin, hemorrhages, they are discussed. And then he is presented in the second part as an expert witness. And this second part is basically the expert witness. That now, for example, the case of injury is there. Now he will comment upon the kind of weapon, that the weapon was sharp-edged or the blunt. Then he will classify the injury according to Qisas and Diyat law, timing of injury, and various other medical legal facts. By inferring the conclusion, the inference which is drawn as an expert, he will present in the court of law, and this will be his second part of the evidence recording. Then the purpose of medical evidence is to lay before the court the entire medical information, what he knows about the case. And he should not omit any portion of finding for any reason. The medical practitioner in person gives evidences, and they should only restrict to the evidence, the facts of the case. So the medical evidence should be factual and should be relevant. The medical documents like hospital notes, bedhead tickets, treatment charts, investigation, they can be produced by the doctor as an evidence, and he can present, he can read them out. And the medical publication can also be produced in the court of law as an authentic opinion. The medical witness is an integral part of the administration of the justice, because he is an expert and he is going to classify the injury according to Qisas and Diyat ordinance. Because the court, the lawyers, they are not the doctors. The doctors will produce the evidence that this is injury upon his anatomical knowledge, upon his physiological knowledge. He will present that this injury caused the death. This injury was due to weapon. So he present himself as an expert witness. And he helps the court by presenting as an expert witness. He helps the court in the proceedings. Then he should present himself according to the expectation of the court. And what is the process? That after swearing in, that is after the oath, which is normally, I swear to the Almighty Allah that I will tell the truth, the whole truth, nothing but the truth. And the recording of the evidence will be that the doctor should strictly adhere to the principles of recording. Secondly, take the records of the case with you, and you should know all the details of the case. That before going to the court, you read out that case which you are going to present in the court, and you should know all the details. You should collect all the evidences which you have to take along. For example, you have to take not only the record of the MLC, record of the postmortem report, but also the hospital record or other record which is necessary that should be presented. Then speak briefly, clearly, and in non-technical, understandable language. And do not use technical knowledge or technical language which is not understandable to the court. So explain them in non-technical terms. Then listen carefully before you give any answer. The answer will be put to you in the cross-examination, and you should listen carefully and then answer. Always address the court, sir. Whenever an answer and a question is put to you, you should always address to the court, not to the person who is putting the question. Then do not answer with anger. If you do not agree with the suggestion, then disagree firmly but politely, because the lawyers, defense lawyers, they put hostile questions like, doctor, you have taken the money, or doctor, you have wrongly interpreted the report. So you should simply politely say, this is incorrect to state. Don't become in anger. Don't lose your temper. Be polite and simply say, this is incorrect to state. Then do not avoid any question. If does not know any answer, admit it. And lack of knowledge should be told to the court that this I do not know. And then you can consult the book, or you can ask that I can consult a book to answer this. So you express your lack of knowledge. Do not give the wrong answers. Then do not avoid any question. If you do not know, do show your lack of knowledge. Be impartial and read carefully any book or record which is shown to you for the comments. Then seek permission of the court before leaving. Now about the invisible triangle. The judge is sitting on the head chair. On the left side is the prosecution, and you as a witness are brought to the court from the prosecution side. And on the right side, there is a defense counsel, which is the questioner. So these three, judge, witness, and questioner, they make a triangle. And you should always address to the judge. The questioner puts a question to you, you listen that question, then after listening the question from the questioner or the defense counsel, address to the judge, answer to the judge, sir, do not look or do not address the defense counsel or the person who is putting you the question. So this is invisible triangle, that you should always listen the question and address to the judge for its answer. Then you can leave with the permission of the court. So the summary of today's talk is that we've discussed what are stages of recording, evidence recording, and they are the examination in chief, the cross-examination, the re-examination. Then I have discussed the evidence recording or the testimony of a doctor, and after the oath, all the stages of examination, they are observed, and there is an invisible triangle, and you should always address to the judge in replying the answer. Thank you very much. So this is all about today's lecture. Take care, and we'll continue in the lecture, the law. Please subscribe to my channel, and this is